in London, part of the law firm of Kohm and Melnitzer. I think Mr. Melnitzer's basic background in rent review came from representing landlord associations in their lobbying efforts with the government on various rent review matters. More recently, the Tom Commission of Inquiry, Mr. Melnitzer was counsel for the landlord advocacy groups. He's currently counsel to the Fair Rental Policy Organization of Ontario since 1985, and is extremely and actively involved in current and ongoing rent review applications, etc. Mr. Melnitzer?
Thank you, Richard. The 30 or any one of the three topics which I've been asked to cover exhaustively and clearly in the next 30 minutes, that is issues affecting post-75 buildings, the rent registry and illegal rents, and a checklist for solicitors acting on the purchase of an apartment complex, except for perhaps well, I guess all of them could easily take a day to deal with. But I'm going to spend the bulk of my time on the first two, issues affecting post-75 buildings and the rent registry and illegal rents. And let me start with really the registry, because the base rent is indeed the core of any proceeding under this statute, unless the administrator establishes a base rent. He has nothing upon which to base his increase. So virtually everything involves, as a threshold issue, the determination of the base rent. And let me consider the effect of the registry. Ultimately, you should think of the registry system much the way you do of the PPSA or any kind of title system. It's a universal, eventually, a universal assurance that what you see is what you get. Now that's true, except for this fundamental difficulty that's already been alluded to. The curtain hasn't gone up. The registry, first of all, although I understand that about 85% of landlords who were required to register in Ontario have in fact registered. By require to register, that applies to landlords with complexes of 7 units or more. Now, having obtained all this information, the ministry has to get it into the computer and has to make sure it's fed in right. Now, quite apart from blaming not the ministry, but the politicians who didn't give them very much time or enough resources, let me assure you that landlords are having a very difficult time, and I know for a fact that to this very day, almost 1 year after the registration deadline in May of '87, corrections and amendments are still being filed by landlords who are starting to learn what the Act means. The impact of all of this is that the time period which would give the rent registry effect, that is to say, that one would be allowed to assume that what's in the registry is the valid rent, has not yet started to run. That period starts to run only from the time that the ministry gives notice to landlords and tenants of what actually has been entered into that computer. And from the time that that notice is given, either a 90-day period or a 2-year period kicks in. The 90-day period applies in cases where there are previous orders and where the ministry has determined that the rents that's registered is no more than 5% off what would have been legal under the old system. In cases where there are no orders, or the rent on its face, shall we say, appears to be more than 5% off apparent legality, there's a 2-year period. So this, keeping in mind that the vast majority of units in Ontario were not subject to orders, we know that the majority of rents in this province will not have certain status as to their legality until 2 years from a point in time that is yet to arise. Compounding these difficulties are the fact that, for various reasons and without any way attributing fault, I know of at least 4,000 notifications that have gone out that are wrong on 4,000 units. Those notifications say that there are no orders when in fact there are orders. The way we know that is because the landlord has the usual horrible memories of going through the rent review process and can't possibly be wrong. So there are going to be, as in any massive undertaking of this sort, the bureaucratic and computer glitches. Well, since I'm here from a landlord's perspective, what does the landlord do in the meantime? The difficulties this creates are very fundamental. Difficulty number one: how do you fill out your notice of rent increase? Not directly tied to the registry, but all part of the same problem. What do you do when the tenant says, your registered rent is illegal, I, or TPA, has done the calculation for me, and your rent's illegal, I'm deducting such and such an amount, sue me if you like, and on top of that you owe me a rebate, going back to August of 1985. This has detrimental effects on the landlord's favorite item, which is cash flow. I can tell you that the problem is extremely vexing. It's vexing because there are jurisdictional difficulties. Consider the possibilities. The landlord says, you bum. You're not paying your rent because you just bought an Eldorado. Why should GM Credit Corporation get the money that I'm entitled to? I'm going to go see Judge Fair. Now, we know that as far as landlord goes, the presence of Judges Fair in the district court in Toronto are minimal. But what's the judge going to say? And realistically, what is the judge going to say if what the tenant pulls out is a rent roll filed by a previous landlord on an application that had been withdrawn under the old system, and which on its face appears to give rise to the very cogent argument the landlord has routinely taken increases of 37%, which on their face appear to be illegal. Now, if you spend a little time in the courts, you might quickly reach the conclusion that the equities would then not be in favor of the landlord, especially if the tenant comes with his 3 kids and Kay Gardner. Now, at the very best, what you're likely to get in the district court is an adjournment on the grounds that, especially under this act, there's no way a district court judge can deal with it. So there's a very, very difficult problem. If you're looking for some help, if you're going to try to make an argument, I think it's been successfully made in one case in London that Section 61(3) of the Act, and I'm not going to go into the details here because I don't have much time, but can be read to say that the rent which has been filed with the registry is the legal rent until such time as it's challenged. Now, What we did in this case in London is we carved out of the mass of rent of tenants that TPA was representing a group of tenants who had filed no application for a rebate. That was the key. And we convinced Judge Winter down there to give us an injunction and an accounting, et cetera, on the grounds, first of all, that Section 61(3) held the rent in place as a legal rent until it was challenged. Now, the issue that didn't arise on that application was whether, if there's a bare challenge made by the tenant, what happens in the time between the application and the decision. That has to be dealt with at a later point. But Section 61(3), I think, has this advantage as time goes on. You can argue to a judge that unless it's read this way, it's the only thing that's going to prevent chaos. The other difficulty that we deal with in our paper, and I don't think it's troubled me for quite a while, and I don't hear much about it, but it's basically this. What's the relationship between rent registered in 1985 and orders made after 85 as a result of applications made before 85? It's hard to tell on the face of the act what the interrelationship is between the deeming of the registry rent to be lawful and the fact that an order is made after registration which is not in sync. That registration. That's a problem that's going to arise. You should watch out for it. Now, I should tell you that we were assured as recently, when I say we, I mean the Committee of Fair Rental Policy Organization, as recently as last week, that administrators will not deal with rebate applications under the new Act until, if the landlord has indicated any intention to defend by way of justifying under Section 61. Section 61 and 62 effectively allow a landlord, under circumstances yet to be regulated, to legalize a rent which was illegal under the old Act. The exact way in which that will be done has not yet been regulated, although one way has been legislated, and that way is simply that what you do is you take the landlord's 75 rent or the most recent pre-85 order, add the statutory increases, and if he's on side, he's all right. Now, the difference between that and the way the system used to work was that if you had an 80 order for $100 and a 5% guideline, if you skipped one rent increase, you couldn't catch up the next year. One aspect of the justification provision lumps the increases you were allowed to take together cumulatively and looks at the overall result rather than the year-to-year validity of the increase. But in addition to that, there's going to be a set of regulation that may allow a landlord to justify on the basis of, I could have got this increase if I'd gone to rent review, although I didn't. That's the general policy. Now, just how they're going to do it, we don't know. So what's going to happen now is that you have a landlord who comes to you with a rebate application. The first thing you do is indicate that you intend to make use of the justification provision. That will effectively stop the rebate application. Then when you see the regulation, you can determine whether or not you're going to be able to take advantage of it. But you see what's happening is that there's this sort of cumulative, exponential backlog building up because all these things are related to each other. My guess is that it will be 1992 before the registry system has any real impact here. I'm obviously not going to have time to deal with this, but let me tell you that has tremendous implications for solicitors doing conveyancing. We deal with them in the paper, and I'll leave it at that. Let me talk about post-75 buildings. I think I've got to about 12, Richard. Is that?
Right.
Okay. Post-75 buildings are indeed free of many of the base rent problems inherent in pre-76 buildings for the simple reason that they have no pre-August 1st, 85 history that's relevant to the determination of base rent. Now, so what that means is that if you were telling the truth, your client was telling the truth when he registered, his legal rent should notionally be easy to calculate because you just add statutory increases since that time. The only difficulty is that the act was retroactive for a period of 16 months. Now, let me tell you my view, and it's only one man's view of what a legal rent on a post-75 building is today. And this is the advice I've been giving my clients, with the appropriate disclaimer. It's this. If you look through the history of rent review legislation, you see that increases above statutory guideline were always, well, I shouldn't say always, but were uncollectible until you obtain an order. In other words, if the landlord wanted to diverge from the norm being the guideline, he had to go make an application. If somebody said to you, that's all right, then the increase kicked in, and he could calculate his legal rent, although he probably couldn't collect it, because all the tenants either had left or weren't putting their money in the bank. The fundamental difference with respect to post-75 landlords is that landlords' increases charged in excess of the statutory guideline between August 1st, 85 and December 31st, 86, the retroactive period for this act, are in fact, in my view, deemed to be legal unless an order declares them otherwise. So that in my view, the legal rent today and the proper maximum is the actual increase taken, or any increases taken in the period between August 1st, 85 and December 86. I shouldn't say increase taken, notice of increase given, December 31st, 86, plus statutory increases since that time. Let me repeat that because it's a bit complicated. Let's assume a landlord, without compounding anything, had September and August anniversary date, and he had $100 rent in August of 84. He took 10% in August of 85, 10% in August of 86, 10% of August of 87, and 10% in August of 87. So without compounding, what he's trying to do is get himself in a position where right now his legal rent's $130. In my view, his current legal maximum rent is the 10% he took in 85, even though the guideline was only 4%, because the Act says in the retroactive period, whatever you took is legal until an order declares it otherwise. And all we know, as we hear, there's 25,000 sitting out there. His 10% increase in August of 86 is also, as of this moment, when he files his new notice of rent increase, legal. There's 120. But his August of 87, if he gave a notice of 10%, is not, because his August of 87 increase was not collectible or chargeable, unlike those increases in the retroactive period, until the order is actually made. So his legal rent now is 100 plus 10 for the 85 increase, 10 for the 86 increase, and 5.2 for the 87 increase. So somewhere in the neighborhood of $126. That's my view of what the August 1st, 85 to December 31st, 86. And let me point out that you don't look at whether the increase actually took effect on December 31st of 86, as long as the notice was given in December of 86, before December, on or before December 31st of 86. That's an important issue affecting post-75 buildings. One may say the most important issue because it goes right to running the building day to day. The other issues, well, there are many of them which arise, are issues relating, of course, to these retroactive applications. What creates a great deal of the difficulty with the application? Well, difficulty number one, everyone was required to file their retroactive application by March 2nd of 1987, at which point in time there were no regulations. A set of economic regulations came out in May and a different set in July. Wasn't May? Sorry? There was one set in the spring and another one in the summer. The question is, which apply to your application? Let me assure you that in certain cases that's a very important question. You can solve the problem while not accepting the result by writing the ministry. They've put out a little blurb that the Fair Rental Policy Organization has, and I think all the consultants here have them, in which they set out what applies to what. And their basic philosophy is this. Ontario Regulation 93 of 87, the first set of economic regulation, applies to all cost revenue statements filed until such time as the second set of economic regulations came out. To all applications filed before the second set of economic regulations came out. So in other words, if everybody who filed on March 2nd of 87 is prima facie, at first blush for the non-lawyers, is at first blush governed by the first set of economic regulation, except, and here's the rub, except to the extent that the second set of economic regulation does not contradict or vary, but merely supplements the first or deals with new matters. Now, for those of you who've dealt with the parole evidence rule in the courtroom, this is something like that. I urge you that if you're acting for a client, not to accept this. I have a lot of doubts about the way some of these are being interpreted, and some of them are absolutely crucial. For example, the most obvious form of prejudice resulting from a very insignificant change is the provision in the second set of economic regulations which requires a landlord to own a building for some portion of the base year before he can claim the first 12 months of financing costs. This is completely contrary to the practice under the old Act, and I suspect completely contrary to the way in which the base year or the accounting periods were filed by many landlords who filed early cost revenue statement. I can tell you that many of the consultants were saved from making this mistake only by the workload and the confusion which resulted in everybody filing late, so that by that time they knew about the second regulation. But those who were first off the mark are also first in the grave on that particular issue. So that's something to watch for. Don't pick up the most recent set of regulation and assume that they're the ones that apply. The truth is that it's Ontario Regulation 93, now for all intents and purposes repealed by 440, which is in effect for most of the application. That's a very desirable state of affairs. 95% of the applications we have are now governed by a regulation which has in effect been repealed. You can draw your own conclusions about the rationale of that. But in any event, I should be going into the heart of the regulations itself. The other thing you're going to find are three vital notice requirements. And while these have application in some cases of financial loss to pre-76 buildings, they're generally found under sections 35 sub 3, 44 sub 5, and 92 sub 2 of the regulation. It's all in the notes, the numbers and the regulation. All of these notice periods, to some extent, deal with arise from what's called the ability to make a phase-in order. In other words, in the old days, if you had a financial loss and were prohibited from collecting all of it in your first increase, you had to go back time and time again until you, in fact, cleared off that financial loss. That's no longer the case. The ministry can, in effect, make an order which lets you run through those increases and build them into your notices until such time as you've got the full benefit of the order. Now, in order to give effect to those phase-ins, there's a number of calculations that have to be done because your basic numbers change every year. If you're only allowed 5% of your rent as the amount that can go in the increase towards financial loss, that 5% will change every year. So that the base on which you calculate the 5% will change every year. So I guess the ministry, the legislators just didn't want a lot of trouble, and there's a formal mechanism to determine exactly what that will be and what notice the tenants will get. If you've got an ARP provision, which changes every year, in other words, the payments are different or the advances are different, that'll affect your phase-in, and there's a special notice that has to be dealt with there as well. But these kinds of notices, the difficulty with them all is that the time period for giving them has long passed. That isn't dealt with in the regulation. What there is in the regulations is a provision for extensions of time. We routinely ask for those extensions in the application. I understand the ministry is now formulating a way to deal with this. Let me tell you this. If you are acting on a rent review order and you have a phase-in order and you're explaining it to your client, in my view, you're looking at a negligence action if you don't advise the client of what he has to do to make that order effective over the next few years. So you must be aware of these notice requirements. Even if it is not good enough from a landlord's point of view to simply consider whether you should appeal. One of the most important issues arises from an anomaly. This relates only to post-75 building in the retroactive provisions of Bill 51. Many of you are probably familiar with the fact that under the old legislation, not only was the amount of the annual increase limited, but the number of times in which you could take the increase in any year was limited to one. In other words, you could take an increase once in every 12-month period. If your limit was 4%, you couldn't take 2% in May and 2% in November. You can only take an increase once in every 12-month period. That rule carried through under the new legislation. Section 70 of the Act provides that you can only take an increase once in every 12-month period. But what's really interesting is that when you look at the section in the back of the Act, 130, that makes certain portions of the legislation retroactive, it does not make Section 70 retroactive. Now, given the general rule of law, that, or given the presumption against retroactivity, which demands a clear intention on the part, clearly expressed intention on the part of the legislature, either expressly or by implication, that something be made retroactive. There's a very strong argument here that owners of post-75 buildings were in fact entitled to take more than one rent increase in the 16-month retroactive period. For those of you who think this is an academic matter, let me tell you that our experience in our office is it arises all the time. It arises all the time, and it's very, very important. There's no doubt in my mind that you'll see that in the divisional court. And with all respect, and I mean real respect for Mr. Reineke, let me tell you that I have some doubts about the assertion that administrators don't really toe the line, because when we spoke to certain administrators about this submission, which appears in detail in the legal submissions that we do, we were told that there had been a policy decision made that only one increase was allowed, and that was that, so that we could make legal arguments till we were blue in the face, but they really weren't even going to think about them. Now, that's not to say that the people up there giving advice haven't thought about that, but I'm saying that I tend to the view that based both on what we've heard so far and on past experience with these kinds of setups, that what's in the operating guide and what comes out of the legal department is going to be what is. That most likely, if you've got a point that's a departure from the norm, you're going to have to find a special administrator, or you're going to end up in the divisional court. Now, I might be wrong. I can only speak about the experience to date. But keep your eye on that more than once a year increase in the 16-month period. Bob Doumani and I, who talked about a lot of the issues here, are of the view that many of the regulations are in fact ultra vires. You should not accept these regulations at face value. Some of the most crucial regulations here, in my view, are the ones most susceptible to attack. For example, the Act provides that the 5% cap on financial loss does not apply to merchant building situations, nor does it apply to agreements for purchase and sale entered into after April 1886.
Lost your mic.
This is a very subtle way of telling me it's 3 minutes to 12. As if I couldn't tell from the expressions on the faces of the audience. However, that 5% cap, the regulation goes on to say, well, we're not going to apply the 5% cap because the Act says we can't do it, but we'll apply a modified version of the 5% cap. You know, what we'll do is we're going to hang you with a longer noose. To me, now, that regulation just flies right in the face of the Act. Just doesn't apply. It just doesn't fit within the parameters. The argument's been made that much of these regulations are legislation, not regulation, and therefore they're ultra vires as well. You'll notice in the Act that there is a general power in the minister to define any term that's not defined in the Act. I think there's some question as to whether the granting of that power itself is an improper delegation, and so on and so forth. Now, dealing with post-75 buildings specifically, of course, everybody filed retroactively for two periods, the 85 period and the 86 period. And many took the cautionary point of view of filing for the 87 period as well, because they didn't have their 85 and 86 orders, and filing now for the 88 period. It is not safe to rely on the phase-ins. The reason it's not safe to rely on the phase-ins is because you don't know how they're going to be applied. You don't know the problems you're going to have with notices. You don't know whether what's going to be allowed will make you take a different look at your 87 numbers and suddenly make a current application that seemed irrelevant now relevant. So the issue is, what do you do about these applications that you have out there? You have an 85 application, and the ministry writes you a letter, say, this is what they were doing, which is file everything, your materials for all the applications. After some disparate treatment throughout the province, a lot of yelling and screaming, for the most part, the ministry has taken a consistent position now, which is that you need only file the materials to support your first application, that is the 85 application. But generally, they are requiring an undertaking that within 35 days, that's a little more than the appeal period, of the granting of the first order, you will either abandon your second application or file. In other words, you can decide whether you want to take advantage of the phase-in provisions or proceed with your second application. Now, 35 days isn't a lot of time to get that material ready, but let me say that the ministry has been more than agreeable in granting extensions. Finally, at 1 minute past 12, let me put in one good word for this particular bureaucracy. It's a very, very responsive one, we found. I think everyone who's been working in the area has. Don't be afraid to pick up the phone and call the administrator. They may be bound by certain regulations, and you may not like the way they interpret it, but your phone calls will be answered, and generally requests for extensions, we find, are treated most reasonably. And you don't get blanket approaches. In fact, in the past week, we got retained on something that was due on Monday, and I think we were thinking about a 2-week extension. The administrator said, you better come down and see this file. You may want more time. I suppose that augurs well for making practice in this area a little more pleasant than the legislation itself makes it. Thank you.
Let me provide you with a brief recap. Don't leave yet because we have one more speaker. I'll give you a brief counting of what we're going to do. We're going to have Ken Hale who's going to talk about the rent registry, illegal rents from the tenant's point of view. I suspect he'll take us up to 12:15. We're then going to break for lunch and come back at 1:30. This afternoon, there'll be 3 speakers addressing issues on appeal, that is procedure, preparing appeals from the first level. And then we're going to have a mock hearing where we'll be taking some of the issues off that cost revenue statement we looked at earlier this morning and running them through an appeal with presentation, witnesses, etc. So I hope you'll come back after lunch. Let me introduce Ken Hale. Ken graduated as a lawyer in 1977, and he's been practicing in the area of landlord-tenant rent review since that time, mainly for various legal clinics operated by the Office of the Attorney General Legal Aid Committee. Ken would be a barrister type within the rent review system. He's in the pits day in, day out, both in district court and at rent review, defending tenants on a basis of coming into legal clinics and needing a quick fix for very complicated legislation. So I'll turn it to Ken. Would you like to sit? You can sit. You stand, grab that pop.
Julius got to stand up. I guess I should. Well, I guess now you've heard the blues about rent review from the landlord's point of view. From the tenant's point of view, it's much worse. In fact, about the only thing that tenants got out of this whole process, despite what the impression you might be left with by Julius, is the rent registry. And in view of the fact that there's a long and complicated process by which the rents are determined and decisions are made and there's appeals, it's some comfort that there is now a scheme that's set up for somebody to determine what the rent actually is on a place and a means by which you can apply to realistically think you might get any overpayments back. This is in sharp contrast to what we had before, and where there was virtually no assistance in finding out what the legal rent was to a tenant, and unless the landlord had previously applied for an order. Essentially, it's my view that the Residential Premises Rent Review Act and Residential Tenancies Act were voluntary on the part of landlords, and if they didn't feel like complying with them and wanted to just pretend they weren't there, well, there weren't any serious consequences to that. And I think that seriously undermined the policy that the government was trying to enact in the legislation. The result is the present Deputy Minister of Housing has estimated that at the time the new Rent Regulation Act was introduced, half the rents in the province are in excess of that permitted by law. But this is all supposed to change with the introduction of the rent registry provided in sections 54 to 69. Although there are important qualifications to the way that the registry works, it's likely to have a very serious impact to tenants' benefit if and when it comes into effect. We've heard about the requirement that every landlord was supposed to comply with of filing a rent registry statement. That was May 1st, 87. One thing that Julius omitted to mention about the importance of those statements was that the rent registry statement is supposed to contain information about what services and facilities are included in that rent. And that seems to be a major source of problems and questions which maybe we can deal with in a minute or two. Once the ministry reviews the information, a notice is sent out to the tenant saying what was filed and what information was obtained from previous orders. It doesn't necessarily tell the tenants to contact their lawyer and make a rebate application where it's clear that it's illegal, but it's supposed to be a reasonable implication of the information that you get. We've heard about the 90 days and a 2-year period, so I won't really go into that. But it is nice to know that landlords are allowed to register a 5% increase just sort of gratuitously as the ministry's way of kind of forgiving some minor illegalities. After the period's expired and for the dispute to be made, whatever the landlord submitted, assuming that it's not corrected by the minister on her own motion, is the lawful maximum rent as of July 1st, 1985. And it doesn't appear that there's really any way in the rent review process to go behind that. You're stuck with it. And that's why it's important, despite the fact that many of these registry notification forms are ending up in garbage pails in the lobbies of apartment buildings. They are very important and should be checked out in a great deal of detail. I've heard the same rumor that 85% of the landlords have complied with their obligations and registered. I'd like to just quickly go through the carrots and sticks that the legislation provides to require this compliance. First, it's an offense to knowingly fail to file a registration statement, and substantial penalties could, in theory, be imposed on landlords who failed. But the next thing that happens, and maybe this is a little more important, if the registration statement was filed on time, the minister cannot make an order for payment of illegal rents in respect of any period prior to August 85. This is known in the trade as the amnesty provision. It does raise a question as to the conflict between the sections in this act and the predecessor act that says the tenant is not liable to pay these amounts, and maybe it's not a complete amnesty. But it's certainly a strong incentive to landlords to get their registration statements in and let bygones be bygones. Thirdly, you can't make an application if you're a landlord if you haven't filed your registry statement. And even guideline increases may be held up. It doesn't by itself seem to be too much of a deterrent to landlords who want to just continue to pretend that rent regulation doesn't exist. But then, as Julius has mentioned, there's the 10-year retroactive justification, which to my mind is probably the single most bizarre section in the legislation. It allows the landlord to justify the actual presently illegal rent by adding to a legal base rent increases that could have been justified on or after the 29th day of July 1975 and before the first day of August 1985. So I ignored the law, but if I would have applied, I could have got these increases. So why don't you give them to me now and let bygones be bygones. I think the reason that the ministry is still struggling with drafting these regulations and why they don't exist yet is that the provision is bizarre. And someday maybe these regulations will come out, and it is potentially a nightmare for tenants and for their representatives, and all in the unworthy cause of paying off lawbreakers. The notices are starting to trickle out of the ministry of what's being registered, and tenants may start showing up asking you what these notices are, what they mean, what they're supposed to do. First thing that has to be kept in mind is an application to correct the registry and an application for return of what's euphemistically called excess rent are separate and distinct proceedings. Proving that an illegal rent has been registered doesn't get the tenant's money back, and a separate application has been made. And even if you may not always want to correct information in the registry, it is possible that the landlord could file something which you don't know to be correct that may be to your advantage, to just leave it that way. So I think that applications to correct the registry should only be considered where the rent charged in July 85 was less than that stated in the registration notice, and that makes sure that the higher amount doesn't become the lawful base. If the unit was occupied by somebody else in August 85, you have the same problems that you have presently in proving an illegal rent without a rent registry. And the delay that continues in implementing the registry is putting tenants at serious disadvantages because more and more units are turning over, and the people who have moved out of those units are moving on to other places and disappearing. But it should be remembered that any application, any dispute to the registry information may open up the 10-year retroactive review to justify the registered rent, and as I said, it looks like a nightmare. It's also recommended that disputes be made where the registration notices don't include the proper information about services and facilities included in the basic rent. I think the most common one here is cable TV, where landlords omit to put cable TV as an included service and facility where it is, because there's a large move to individual billing in cable TV. Some landlords have changed from group billing to individual billing between July 85 and the present time, and so they're going to forget that on July 85 it was included. There's a list of services and facilities under the definition section in section 1, and that's maybe a useful guide to the type of things you might consider disputing, like locker space should be in there if it was included, because a tenant who loses services in the future of things that aren't on the registration statement, once it becomes final, I think as far as the ministry is concerned, they're completely out of luck, and they're not going to get any rebate or refund for those services if they're discontinued. And I also think they're unlikely to get much sympathy from the courts in some kind of application for a return of the value of those services because it wasn't on the registry statement. Recently there was a reported case in which the tenant signed an acknowledgement of tenancy and there weren't some services and facilities included in there, and the tenant was out of luck, and I think a similar situation is going to obtain with the registration statements. It may be that you might not have to go through the whole procedure of doing a dispute for services and facilities that the landlord agrees are included but just are left off the statement. It may be dealt with under the clerical error provisions, but we don't really know. If the registration notice indicates that the tenant's paying an illegal rent, that is, where the rent charged is more than what the landlord has registered, a number of questions arise. First, do you initiate an application for a return of the overpayment? or do you attempt to recover the monies outside the ministry process? There's a lot of factors you have to keep in mind. Whether Julius is representing the landlord may be one of them. But first, there's the $3,000 limit for ministry orders and potential costs and other difficulties in making an application to court for amounts above $3,000. The size of the backlog at the appropriate ministry office, whether your tenant client wants to wait for 5 years to get his rent rebate ordered, let alone appealed and collected. History of the relations between the parties, willingness of the tenant to put their tenancy at risk in an arrears application. In many cases, maybe we can assume that a landlord who's honest enough to confess in his registration statement that he charged an illegal rent will be willing to negotiate the repayment to the tenant without too much fuss, but certainly not universally true. I think that also raises a reminder that any time you get an application against the tenant for arrears of rent, there is an obligation to determine what the legal rent is in the best manner that you can. And once the registry actually comes into effect, it might be easy, it might not be too easy now, but there's probably hundreds of people evicted every year for rent that they weren't liable for. And as a tenant representative, I think one has an obligation to try to figure out if that's the case. You also have to take into account whether or not the tenant plans to stay there when you're deciding whether or not to make an application or do some negotiating outside the act, because it's much easier to collect from somebody you have an ongoing payment obligation to than a former landlord. And finally, as Julius mentioned, the landlord gets all his guideline increases, whether or not they were requested or collected or agreed to or anything in the period from 75 up to the present. So I'd just like to make a few final comments about each of these topics. One is, there's a general policy of public access to information in the registry, subject to payments of fees and some limitations. Secondly, the registry automatically updates itself by incorporating guideline increase every year, any new orders or other relevant changes, and that is irrespective of whether or not the rent increase was actually requested or charged. It means that even if a tenant's rent isn't actually increased by the service of a notice, the maximum legal rent goes up, and the tenant's rent can be increased to that amount at any time, subject to the 90 days notice and subject to the 1 increase per year rule. It also means that a new tenant can be charged that rent from the inception of the tenancy, subject to Section 70. And to conclude on illegal rent, many of the same problems that made the old system so useless from the tenant's point of view are still there. In the absence of a rent registry notice being served and you knowing what the ministry thinks the legal rent is, former tenants must be traced, persuaded to dig up old records, many of which may have long since disappeared. The lack of a hearing process and subpoena power at the first level compounds the difficulty and makes it impossible to get the information from the landlord or the former landlord. The registration process for 6 units and under hasn't even started. This is the housing that the majority of tenants in this province live in, and this is also the housing that the majority of landlords decided not to opt into rent review in its first 10 years of operation. So there still are formidable difficulties for tenants trying to enforce the law, and given the backlog of work that the ministry has, it doesn't appear that the ministry is going to be in a position to, on their own motion, enforce a lot of these overpayments and rent reductions. Therefore, it's the tenants that have to do it. But with 50% of the rents illegal and this potentially continuing for a number of years, there may be large sums out there just waiting for people to recover them, and your chances of recovering something under this seem to be fairly substantial once the information is all in, and that maybe tenants would be best advised to stop buying lottery tickets and save up their money to invest in the rent review lottery, because the odds seem to be a lot better.
Thank you, Ken. If people have questions, you can pop them on the desk here. We'll have a look at them after lunch. We hope to get back here at 1:30 and start again. Thanks. The next speaker to talk about the appeals process, which occurs after Mr. Reineke gives his decision and parties are unhappy with it, is David Burnside, who is senior legal counsel to the Hearings Board. The Hearings Board has its own legal staff. Perhaps David will talk about that. David Burnside has been a rent review commissioner both part-time and full-time for the past 6 years. On the resume he handed to me, he states that he was successfully a commissioner, a managing commissioner, and appeal commissioner. I take it the word success means he managed to survive 5 traumatic years. He's a solicitor and he's called to the bar in 1977, which is interesting because there's 3 panel members today who spoke so far who've been called to the bar in that year. So I guess it was a great year for rent review solicitors. David?
Thank you, Richard. In reading my resume, you indicated that I stated I was successful. Perhaps that's a typographical. Perhaps what I meant to say was that in succession, I served in so many roles. As to whether I was successful or not, I leave that open. The reason why I'm here basically is, I think, Richard's revenge. Richard knows that I'm an avid ball fan and has known that for a few years. So, of course, when it comes to opening day, when the Blue Jays come into town having to fight those nasty Yankees who are ahead 5-0 at this point, what's he... No, that in record, not in the game. It hasn't started yet. What does he do? But he schedules me to be involved in this continuing education course. And not only that, Richard decides to nail things down by having me actually start talking during the opening pitch. I can't even wear a Walkman. Anyway, I am here representing a quasi-judicial tribunal, so I have to be serious, also serious. I cannot, like other people earlier today, mouth off about the legislation. I'll leave that to them. What our body is an appeal body, and after the administrative review process, which is what we've been talking about this morning, has been completed, it's possible for a landlord or tenant who's directly affected by the order of the administrator to appeal to the Rent Review Hearings Board. To give you a general overview as to what we are at this time, we have 24 members, 4 recently new appointees, and those 24 include a chairman and vice chairman who reside at head office in Toronto. We have 3 members in the Southwest region, 2 in the North, 3 in the East, and 14 in the Central region. The 4 regional offices are located in London, Sudbury, Ottawa, and Toronto. The hearings will be held in the regional offices in those cities, as well as throughout the province where necessary. Obviously, in servicing certain areas, we'll hold hearings in Hamilton as opposed to London, and in Thunder Bay as opposed to Sudbury. 1 member of the hearings board will sit unless a panel of 3 is requested by the parties. What I intend to do now is to give you a general overview of 3 particular areas. What is basically who may appeal and how and where to do it. What is the evidence that's going to be considered on appeal? And perhaps the most important of all, what is the nature of the hearing? Now, in the materials that were handed out, you'll notice that we have chapters K and L, which forms the materials that I sent to be included. And I'll just give you a brief overview. I don't plan to review these materials. I leave it up to you to read them. Chapter L is a summary guide to the Residential Rent Regulation Act 1986 and the Statutory Powers Procedure Act, the Statutory Powers Procedure Act being applicable to proceedings before the board. What you have in that document is basically just a mundane summary of the provisions of the legislation and the SPPA. It does have an index and it does have a table of contents for easy reference. Now, this, as with the other document that has been enclosed in the materials, is what we call an evolving document. That is, it's not final. There will be adjustments to it, particularly as we learn through the hearing, holding a number of hearings, what the process is like and what we may need to supplement. Now, We've heard about different versions of the Act. I gather in the materials today, the bilingual red copy was handed out. There is also a blue consolidation, which I think some of the panel members have and have been referring to. That consolidation was put together in July of 1987. It's a helpful tool to take along with you because it does consolidate the regulations, but there are a couple of matters that I would mention to you as warnings to keep in mind. First of all, it does only consolidate the regulations up until July of 1987. There have been some amendments to regulations since then, and you should be aware of them. Secondly, it consolidates them to the extent that Regulation 44087, which is the economic regulations referred to this morning, they replaced, in July of 1987, replaced the earlier economic determination regulations, which were 9387. Because in one of the sections of 440, it says that 93 is repealed, you'll notice in the consolidated blue book that 93 doesn't appear at all. Now, you have had some discussion this morning as to there may be applications which were filed prior to July of 1987 where parties may wish to argue the applicability of the previous Regulation 93. In that case, you may have to take separate steps through getting copies of the Gazette or whatever to ensure that you do have a copy of 93. What I basically work off of is the original copy of the Act together with all of these little index regulations that have been passed on an ongoing basis. And I mention that because if you look at the draft summary guide, which is Chapter L, you'll see that I make reference to section numbers. Also, there is a little reference like in the first one, appealing an order P55, that says page 55. That's referring to the page number in my original copy of the Act. So if it conflicts with the copy of the Act that you're looking at, forget what page it's on, just concentrate on the section. We have many different versions of the Act, and there's no point in creating further confusion. Now, going back to the chapter immediately preceding that one, which is Chapter K, you'll notice that this is a document which is entitled Interim Guide, Conduct of Hearing, Appealing a Rent Review Decision. This is basically our first public effort at drafting a document to let you know what a hearing before the Hearings Board is like. It is interim because we will be working on it. It will be evolving through the period of time because we're going to learn from the hearings process as a board, as you will representing parties. But this is the roadmap to our proceedings. I will not read through it. I suggest you do. And if you have any comments on it, if you think we've missed something or you feel strongly one way or another about how the proceedings are set out, please do communicate with us. Write to me at the head office of the Hearings Board. We're always receptive to comments, and we're trying to operate as a quasi-judicial tribunal which serves its clientele. And if we can consider suggestions as to procedure that might greater assist the parties, and certainly we're open to consider that. Now, who may appeal? The Act in 101 says a landlord or tenant directly affected may appeal. There's no requirement that that individual be a party to the initial level administrative review proceedings. That's a change from the old system where the Act said you had to have participated in the initial hearing. It's even possible that an individual could acquire the building or a tenant could move in after the administrator's order and still have a right to appeal because they're a landlord or tenant directly affected by the order. The time limit for appeal, set out again in the Act, is 30 days. But it doesn't say 30 days from the date of the administrator's order. It says 30 days from the giving. So that gives rise to a question, what does that mean? Well, we look back to Section 21 sub 2, which says basically if a notice or document is given, it's deemed to be received on the 5th day after mailing. By and large, I understand the practice of rent review services is to mail out a copy of the administrator's order to all of the parties. Therefore, we look at the date of the order, start counting the 5 days. After that, it's deemed to be received on the 5th day, and then we go into our 30 days counting. There is a regulation, an amendment to 749, which sets out how we count in rent review, and basically we don't count the first day on which the event occurs. We start the next day, but we do count the last day of the time period, unless it falls on the various holidays listed in that regulation, in which case we go to the next day. So primarily the way we're starting at the hearings board is you look at the date of the administrator's order and start counting 35 days right after it. And if you end up on a holiday or a weekend, then just go to the next business day, and that's your appeal time period. Where do you appeal? Well, head office or the 4 regional office of the hearings board. To the extent that I gather a large number of you present today are individuals who will be representing various parties on appeals, I would suggest as much as possible to use the head office of the hearings board or the 4 regional offices in which to appeal. Administratively, it's a lot easier. However, there is a mechanism in place where it is possible to file an appeal in one of the 21 offices of Rent Review Services, and there is a mechanism where that appeal will be date stamped and forwarded on to the hearings board for consideration. How to go about appealing? Well, there is a prescribed form, number 5, which is a form that should be completed and filed on appeal. There are 3 other forms that I would mention briefly now, just to give you an idea. The 3 forms that are regulated pursuant to the requirements of the Act. One is Form 6, which you'll find in the materials relating to the mock hearing this afternoon, and that's a request for a panel of 3. Now, as I stated earlier, an appeal will be heard by an individual board member unless one of the parties to the appeal requests a panel of 3. If a party requests a panel of 3, the board has no choice. It has to assign a panel of 3. There is another Form 7, however, that does allow somebody to have second thoughts and withdraw that request. It has to be the same individual, of course, who requested it. It couldn't be another party who wants to put in their 2 cents. Finally, there is a Form 8, which is a request for a pre-hearing conference. A pre-hearing conference is analogous to a pre-trial conference in the civil proceedings. It's new. It's new to our process, and it's something that we are endeavoring to see how it will work. And we're hoping that it will be able to clarify some issues, to be able to identify some matters of concern, perhaps identify parties that should be as part of the appeal process. It doesn't make any final determination, though. It's one board member who sits on a pre-hearing conference. This board member will not appear on the hearing or being part of the panel holding the hearing, if it is a panel. And that board member will make recommendations. Now, the recommendations are not binding. They could be argued pro or con at the hearing as to whether to accept them or not. There may be instances, and certainly we're going to try and see how helpful the pre-hearing conference can be, and I guess time will only tell to see whether it can help resolve a number of issues that come before the hearings board. Now, the second topic that I'm going to cover briefly is what is the evidence that's going to be considered on appeal. Now, whether it's a landlord's whole building review or a tenant's rent rebate or rent reduction application, obviously a number of materials have been filed as part of the administrative review process. The Act provides that those materials come forward to the hearings board and that you will not be required to refile what you've already filed at the initial level. In addition, the application commencing the proceedings, as well as the order and summary of reasons, will be forwarded to the board. Now, after they're forwarded, they form part of our record, but the Act doesn't go on to tell us what to do with them. But I'll talk about that a little bit later. Now, it's possible, and it's specifically set out in the Act, that fresh and additional evidence may be filed on appeal. And that's set out in 101.1, where it allows a party who's appealing to file with their notice of appeal any additional evidence that they intend to rely on which was not filed as part of the administrative review process. And likewise, a respondent to the appeal has 30 days after the filing of the original notice to file any materials they may wish to rely on which were not filed as part of the administrative review process. Now, the immediate question may be, how does the respondent know 30 days after the filing of the notice of appeal to get those materials in? Well, There is a requirement under the Act, under Section 19, to give a copy of the notice of appeal to the other party within 10 days of filing it. So presumably, if things work out, the other parties to the appeal will have at least 20 days in order to put together any materials they may wish to file in support that were not filed at the initial level. In addition, there is a provision in the Act, Section 102.3, which states that the board may consider additional evidence whether it was available or not at the time of the initial level review. And that could give rise to arguments that even if materials are not filed within the time constraints of being with the notice of appeal for an appellant, or within 30 days of that if you're a respondent, if you come to the hearing with something and it's relevant, will the board consider it? Well, it's open to argument that the board may have to consider that, even though it's outside of the time frame, because of Section 102.3, and that's going to require some interpretation and clarification. But I would advise you that the whole idea, I believe, of requiring a time limit in the legislation for filing evidence on appeal is to avoid surprise and avoid adjournments. And if parties want to argue 102.3 and they come to the hearing with some relevant information that has to be considered as part of the decision, it may result in an adjournment to another date in order that the other parties are not surprised, because we do not want surprise as part of the hearing process. And if that's the case, it's just going to unduly delay the entire hearing process and unduly delay the process of giving a final decision. Now, as you can generally see from what I've said, that I'm now moving into the next topic, which is the nature of the hearing. And there's nothing in what I've said so far which would indicate that the appeal hearing is an appeal on the record below. The appeal is not an appeal or review of an administrator's order or summary of reasons. The administrator has issued an order and reasons based on their findings. The hearings board represents the first hearing that has been undertaken in this process, and the hearings board member or panel of members will be making their own findings based on the evidence on file and the evidence and submissions given at the hearing. Now, what will be involved in the appeal will be a complete review of all of the issues that were raised in the initial application. There is a possibility under Section 102.1 that the board may broaden those issues, and it has the power to broaden them if they feel the real merits and the justice of the case warrant it. But what this means basically is that on a whole building review appeal, it may be that a tenant raises one or two issues in the notice of appeal to the hearings board, and what that may do is open up the entire application to be proved by the landlord on appeal. Likewise, for a tenant who brings a rent rebate application and receives an order of an administrator, if a landlord appeals that, it may be necessary for the tenant to prove completely the application at first hand. And the reason for that is the fact that on appeal, the hearings board has at this time taken the position that a hearing is that of original jurisdiction. And the Act requires that the burden of proof be on the initial applicant, unless, of course, it was an order as a result of the minister's own motion, in which case then it would be on the appellant. So basically, it's the first hearing, and you have to come in and prove all of the matters that are set out in the issues of the application. Now, that technically and in theory is what the hearing process is. How that is implemented in a practical sense in hearings before the hearings board may be a completely different result. Technically, all of the issues have to be reviewed, but there is a possibility under the Act, under 102, that all of the parties may agree in writing to limit those issues. However, you'll notice that it says all of the parties. It says in writing. When you have, as in our mock hearing, 300 units, it may be extremely difficult to have all of the 300 units represented in agreeing to all of the issues that are going to be argued on appeal. Has to be in writing, as I've indicated, and it's discretionary as to whether the board accepts it or not, because it says board may, it doesn't say shall. So therefore, even though the parties to the appeal may limit the issues in their own minds on appeal, the board will accept that. However, if they feel for some other reason the real merits and justice of the case warrant an examination of some issues that the parties wish to limit, they will look into that. And that is because basically rent review represents a mixture of considerations in law. It's not strictly an in personam type action between the parties, the tenants and the landlord of the day. It also has an in rem component, which means that a decision today will have an effect on future landlords, will have an effect on future tenants who are moving in who may not be there today. So even though understandings or agreements or deals are made, those are ones that still have to be reviewed in order to ensure that they are fair and in compliance with the legislation. It is possible, however, quite apart from having said that there will be a complete review of all of the issues raised in the initial application, it may be possible to limit them even in circumstances where we have 300 units where chances are you're never going to have all 300 parties represented or all 300 people at a hearing. And that may be that what would happen, and what happens in every instance when a matter comes before the hearings board, is that there is a pre-review of the file by administrative staff, and that will highlight concerns of issues that aren't necessarily raised as part of the appeal process. That gives the board an opportunity of addressing their minds to all of the issues, and in case there are some issues that have not been raised on appeal where the board feels that they should be brought up and examined, they could be considered. However, in a circumstances, which coincidentally is just the example of our mock hearing this afternoon, where the board has reviewed the file and is basically not concerned with those items or those issues which are not raised by any of the parties to the appeal, then, and the parties come to the hearing and they basically, all of the people who are represented and as well as the people who may not be represented indicate that they are content to proceed solely on the basis of two issues, then it may be possible to deal with those two issues and then review any other issues that were part of the initial application, review those in a summary fashion, or perhaps even not touch on them and not, in those circumstances, vary the findings of the administrator below. So technically, the hearing is a complete review of all of the issues raised in the initial application. However, as a practical reaction to that, in a sense, there may be procedures adopted, and this we'll have to see how things evolve with the hearings of the board members. Procedures that will revolve in order to provide a full and fair hearing based on the issues of concern to the parties and any other issues that the hearings board may wish to look into on the real merits and justice of the case. Now, one other topic that I would touch on before completing my remarks would be there has been some discussion concerning the rent review operating guide. That primarily, those discussions this morning relate to the administrative review process, and I understand that as a working tool for that process. The hearings board is not familiar with that and is not a working guide for the hearings board, and therefore they will be making their determinations based on the act and the regulations. There may be some instances where our decisions are the same, or there may be some variance, but it would be up to the parties to argue as to whether it should be interpreted one way or another. That is a summary of the comments, introductory comments that I have at this time. And I'll pass it to Richard, or should I pass it directly to Bob?
I'm going to give it directly to Bob, but Bob is next.
The other interesting point, which we'll try to get back to, is how the first level administrators are going to deal with hearings board decisions. And somebody remind us to try to treat that topic before we close off. What I thought I'd do for starters is just tell you what my approach was, and then set the case for you. Typically, what's going to happen in this system is that you have a first level, what I call paper review, in which the solicitors are unlikely to get deeply involved, at least from the landlord's side. So the first time you'll hear about the decision is you'll get a telephone call, and your client will be muttering oaths about Richard Fink and those guys in the Rent Review Services Division who just jobbed him with a terrible decision, and it's coming by fax. At that point, try to ascertain if there's a rent review consultant involved. If there is, work closely with that consultant. They're extremely familiar with the Act, the regulations, but in particular the financial implications of the decision, what they were trying to achieve through it, and what the result was. So that's the first point I'd ask you to take away with you. The second thing is, you'll notice in the material, for example, at page G1, and also in the later, that both Ken Hale and I served a Form 6 requesting a 3-person panel, which, as Mr. Burnside indicated, is mandatory. Why did I do that? Well, I did it for 3 reasons. Number one, the appeal to the hearings board represents the last kick at the cat on questions of fact. There is no further appeal on an error of fact, or for that matter, in some senses, an error in rent review logic. The appeal route from the hearings board is to the divisional court on a question of law. And the court tends to show deference to the expert tribunal, so that it is difficult, having lost a few, to convince the divisional court that the expert tribunal has erred. Secondly, the issues are complex, generally, especially in the early going, and I would prefer to have 3 minds brought to bear on the problem rather than 1. Thirdly, in the early going, the hearings board is going to be composed of a mixture of people who have considerable experience under the old system and those who have no experience in rent review at all. Now that produces a salutary balance between experience and not having any preconceived notions. But in the early going, I would prefer to have some blend of experience and no preconceived notions on the board, and I've got a better probability of achieving that if I ask for a 3-person panel. Next, you'll notice that I served a request. It may not be in the material. I think it was handed out. There's a Form 8 sitting out there, which is a request for a pre-hearing conference.
Came with the question.
Both Mr. Burnside and I interpret the statute as producing what you might technically call a trial de novo, which means that if nothing else is done, I've got to stand up there and prove every line and every item on the cost revenue statement. Now, I don't want to do that for a couple of reasons. I don't want to spend 3 days of my client's time and money proving the case. And secondly, I don't want to lay open the whole of the application, because who knows what Ken Hale might do to it, for example, or someone sitting on the panel if they get thinking about what's in there. So I think as a matter of good counsel work, you always want to box the case in as tightly as you can. So I served the notice of pre-hearing conference. There are difficulties with that. Number one, as Mr. Burnside mentioned, the board of necessity is setting rent for future unascertainable generations of occupants of the building. So they've got to worry about that. Secondly, it's not always the case that Mr. Hale or Mr. Fink will represent every tenant in the building. You've got to worry about that because the Act does talk about all parties agreeing. Thirdly, you have tenants moving in and out. Nonetheless, I think it's useful for the parties to try to sit down, to try to narrow the issues. It produces administrative efficiency, if nothing else. And you'll see how we dealt with that when we do the mock trial. Lastly, in my opinion, once the issues are reduced, if possible, I've got to call evidence in my case in chief on all issues. If it's a landlord's whole building review appeal or a tenant's whole building review appeal, because the onus remains on the landlord. So I will call all evidence initially on the issues in appeal, because that's consistent with the onus which is placed on the landlord, my client. Now, let me set the case for you. Rather than a pre-trial, the parties agreed to reduce the issues on appeal to 2. In fact, we did that because we didn't want to be here until 8 p.m. tonight. The notice of appeal tries to set out the types of issues which will typically arise, and then we selected 2 which we think will illustrate the process. The points which have been selected, if you turn to page F2 of the material, and just put a mark there, it'll be paragraph number 1 of the landlord's notice of appeal, which you'll find at page F2, as I said. I'll come back to that. And then section G is the tenant's notice of appeal. Page G3, paragraph 2. So just put a check mark next to those. And let me set the issues for you. Let's deal with issue number 1, which deals with a capital expenditure in respect of the parking garage. That was claimed by the landlord. It was some $770,000, not a small item. And if you turn to page E8, which are the summary of reasons for decision of the rent review administrator, you'll see Schedule B3, capital expenditures allowed. If you go down to second full paragraph, you'll see that the landlord's claim for storm windows was disallowed, and then there's the next sentence. Pursuant to Section 20, subsection 1 of Regulation 440/87, the claim for garage repairs in the amount of $770,295 has been considered as part of the acquisition costs. End of quote. What that does is, instead of the relatively more generous treatment of those amounts as a capital expenditure, they've been dumped into acquisition cost. They would only influence the financing costs recognized, which in turn would influence financial loss, which in turn gets capped at 5% per annum until the landlord breaks even. Now, what all that rent review accounting gobbledygook means was my client got shafted. And most of the $770,000 will never see its way into a rent increase unless I can take this out on appeal. So you'll see then, if you move to, well, let me back up a step. I'm going to read to you the regulation which is going to cause us all the problem in this case, because you don't have the regs, I gather. It's Section 20, subsection 1. It's a subsection of the regs which should be burned in your mind if you're acting for purchasers. It says, if capital expenditures have been incurred within 12 months of the acquisition of the residential complex, and if there was an obvious need for the capital expenditures which a prudent purchaser would have taken into consideration in negotiating the purchase price, no allowance for the capital expenditure shall be made, and the cost of it shall be considered as part of the acquisition costs of the complex. So here we have a case, if you look at the cost revenue statement, that the transaction of purchase and sale closed on August 12, 1986. The substantial garage repair commenced in May 1987, which is obviously within the 12-month shadow, the first 12 months of acquisition, but interestingly was finished in September of 1987. And we'll see if anything can be exploited from that. The rent review administrator determined that it having been commenced at that time, and I would think given the date of the decision, he may not have had the information that it was completed, that it was disallowed and dumped into the acquisition cost. The whole of that diatribe and reasoning is found in the landlord's notice of appeal at page F2, which I'd ask you just to take a minute to read to yourselves. And it's paragraph 1, as I said. Now, the last paragraph will not pursue, although it looks to me that the rent review administrator forgot to add the $770,000 into the acquisition cost, but we won't yell and scream about that at this stage. The last interesting sidebar to this appeal is that if you turn to page D4 of the material, section D is the landlord's reply. The tenants had raised the question of the garage in their pleading. If you look at page D4, paragraph 12, which is Mr. Andrade's reply, you'll find that he conceded the point. He has since, I shall tell you, been fired. Since it's a trial de novo, I don't really care about that, although Mr. Hale may try to exploit it to some extent. I'm simply going to put my case in as if I had the burden, as I did in the initial going, regardless of the now late and lamented Mr. Andrade's concession of that point. But that just illustrates some of the breadth of creative advocacy that might be available in this statute. Now let's turn next to what Mr. Hale is going to complain about. If we go to the decision again, and look at page E4 of the summary of reasons, you'll see that page E4 is in essence an index, and it will tell you very quickly what the administrator has done in a summary way. And you'll see, if your eye travels down paragraph B, that he's had allowed an operating cost allowance, capital expenditures, and a financial loss allowance. The number and letter to the right represents the schedule upon which you'll find a more detailed calculation. If you go to Schedule B6, which is found at page E7, and have a look at the heading Financial Loss, you'll see that the first sentence reads, allowed operating and financing costs have exceeded allowed revenue to create a financial loss of $279,182.39. This financial loss is due to increased financing costs resulting from a purchase of the residential complex. End of quote. Now, Mr. Hale has some difficulties with that purchase, and those are set out at page G3, paragraph 2 of his notice of appeal. And you might just take a moment to look at that. For those of us practicing on the landlord's side, we call this part of the general conspiracy theory that's always raised. In any event, what Mr. Hale will be relying on, not anticipating him, but trying to set the ground for you, is Section 4, subsection 2 of Regulation 440 for 1987. And that's the holy grail. That's the economic regulation. That's the guts of the system. It says, and I quote, if the landlord purchases a residential complex in a non-arm's length transaction, A, the minister shall ascertain the real substance of the transaction and the good faith of the participants, and B, the minister may, discretion, recognize the costs relating to the purchase, provided that they do not exceed those that would be experienced in similar market transactions. End of quote. There are a number of definitions that are relevant. Arm's length is defined as meaning the persons involved are not related persons. Makes sense. Related persons are defined and includes a member of the family, a partner, an employee, one corporation which is controlled by another, and the like. And member of the family contains definitions which I guarantee you will drive you crazy. For example, member of the family means with respect to an individual, let me find the one that drives me crazy, the father, mother, or any brother or sister of the person's spouse, or any descendant of such brother or sister. Now, if you descend far enough back, there's a possibility that Richard Fink and I are related, which is something too terrible to contemplate. So we won't get into it in this hearing, I don't think, but we'll one day determine how far one descends into the member of family category. And equally here, it's a good thing that this is a hearing de novo, because if you travel through the initial tenant submissions prepared by Mr. Fink, the question of non-arm's length transaction was not raised. So clearly he has passed from the scene as well, and Mr. Hale has been retained. So we have a somewhat change of personnel in the hearing. Those are the issues. We thought we'd take a 5-minute break just to reorganize the, I think, are we doing that now? We're doing a break now, just to reorganize? Or sorry, Ken wants a right of reply. So I'll yield the floor.
Then maybe we'll take a 5-minute break. People have questions from this morning or after, keep handing them in. We'll do the hearing, then we'll deal with questions and comments members of the panels have. So the timing is to get the mock hearing going at about 2:35. And to finish it at 3:30, which would leave us then a half an hour.
I'd like to thank Bob for his fair and reasonable presentation of our grounds of appeal. The first issue, looking at it from a tenant's perspective, a lot of what I've had to say has been said by the two speakers, so I'm going to be very brief. It's the question of a retainer in this kind of matter for a group of tenants. I think my practice would be quite different from Richard's in that I am retained on the basis of representing all the people in the building with the understanding that they're going to be making decisions democratically. If there were issues like equalization of rent, and also that there's a committee that's chosen at a tenant meeting to instruct me so that I don't have to deal individually with 600 or more people. But in general, these people are all of the same interest, but where questions like equalization arise, I think the only answer really is to say that you're not prepared to make any submissions on those issues, which bring the tenants into conflict with each other, and if they're not happy with that, they can retain somebody to make those arguments or retain somebody to represent the building on a different basis or come to the hearing and make their own representations on those issues. The drafting of the notice of appeal, I think there's two very different situations. One is where you represented the tenants at administrative review, and the other is when you get the order 2 days before the deadline for the notice of appeal to be filed, and that's going to have a significant effect on whether or not how specific your notice is. I think I agree with most of what Bob said about the request for a 3-member panel. A lot of the people that are on the appeal panel are new and are unknown quantities, so you might want to have a little insurance by getting more of them. I do think there is a genuine concern about pre-hearing conference agreements in respect of people who aren't represented. As was indicated, Bob and I could sit down for a whole day and come up with some fabulous agreement, but some tenant who I'm not representing could show up at the hearing and demand that the whole thing be gone through from square one. Whether or not it's likely that that would happen is another question, but it certainly is a concern, and we'll test the patience of the hearing boards at some point, I'm sure. It should be noted that the board has wide powers of conducting inquiries, going out and doing inspections. Sometimes that is a useful idea. It gives the panel members a flavor of what kind of a place they're ordering a 20% rent increase on. They can direct the filing of more documents and impose sanctions on parties who don't obey their directions. They can rehear their case anytime within 1 year. Just two other points about the hearing. One is question of attendance at hearings. People often wonder, well, what's the point of me, a tenant, going to a hearing if I've got these experts representing me? Well, we always encourage everybody to go to the hearing as much as possible. It seems to have a salutary effect on the board members and the landlord's representatives when there's 100 screaming people out there. I think it does bring home to the panel members that they are dealing with real people and there are serious issues and people's security of tenure is there. And having little old ladies in the front row is always good. Question of other people, bringing other people to the hearing, like MPPs and the press and those kind of things. Those are sometimes delicate questions, but a lot of times our politicians don't really know what it is that they've wrought, and this is a way to bring it home to them. Finally, I would suggest that whenever possible to make written submissions at the end of your presentation so that they have something to go home and write their order based on, hopefully.
Okay, we'll adjourn back in 8 minutes at 2:30, and we're going to rearrange the tables. Thanks.